May I please, Your Lordship? I beg to mention hearing item number 4 on behalf of my senior Ezimomi.
Yes.
I beg to mention hearing item number 4 on behalf of my senior Ezimomi. So kindly list this matter after 2 weeks since my senior is in out of station and he is disposed for today.
Yes, who's for the other side?
I'm for the private respondent.
Actually, there's nothing here, is it? Already decided matter by the division bench
Yes.
earlier.
Yes.
There's nothing, you cannot, there's a finality attached. What is there?
In fact, the only grievance we have now is both the respondents are overage now because of the long litigation that has been going on.
You're for the respondent.
Private respondent, yes.
The case of the appellant has been decided by the division bench earlier. Correct? So what survives now? There's nothing that survives.
No, in fact, the appellant wants the post to be advertised.
Okay. So,
Now
but that is not the issue in the earlier cases.
lordship. In fact, both the respondents, they were fighting over the matter, over the post, all these years, for more than 10 years.
So unless you are asked for relaxation of your age, you cannot participate in
Yes,
it.
lordship. That is the only issue that with us, lordship. As far as the private response are concerned.
So why don't you all have you all made representations to the government?
No, not yet. No.
Then what do you mean? Okay, right. We'll adjourn the matter.
Lordship.
On the prayer made for adjournment on behalf of Mr. A. Zimomi, learned counsel for the appellant, which is not objected to by the counsels for the respondents, list the matter on. Give it in.
After 2 weeks.
When?
March, lordship. 2 weeks.
Okay, 25th March.
Okay.
There is an Indian, my lord.
Interim order to continue till the next date.
Deeply obliged, my lord.
Obliged.
I please, Your Lordship, I beg to mention item number 3. Kindly this matter will be listed after 2 weeks.
Yes, Mr. Jamir, you're there.
Yes.
You're not ready? 302 matter. What is there? It's a 302. What? No objection.
Lordship, since it's an appeal against acquittals, I have no objections.
Okay, right. On the prayer for adjournment made on behalf of Mr. C.T. Jamir, Senior Counsel for the appellant, list the matter on
2 weeks, Your Lordship.
date.
April, Your Lordship.
Okay.
Deeply obliged, my lord. Deeply obliged, my lord.
Well, you cannot come one by one and adjourn all the matters.
May I please, Lordship? Lordship, I beg to mention hearing item number 6 on behalf of AIB. Lordship, I kindly list this matter after 1 week. She's in disposed, Lordship. I can get the consent of the petitioner.
Yeah, but I don't know if the court will give consent.
Lordship, I'm ready to take out the matter.
So,
Lordship,
landowner.
Yes, Lordship. Case of multiple landowners, Lordship.
He's a multiple landowner. So,
Yes, Lord.
you are what? The grandson, great grandson. What are you?
Lordship, my ancestors, they have donated land in the year 1960, Lordship.
That's what.
And adjacent to that land, Lordship, there was also another landowner.
Ah.
So, the other landowner, they have enjoyed the benefit on 3 occasions.
Okay.
Now, the state government, they have come up with a policy, Lordship, in the year 2018.
Correct.
So, and clause 3C specifically says that no perpetuity on appointment cannot be made on perpetuity.
Is there the agreement? Is it in writing?
Lordship?
Is the agreement in writing?
No, Lordship, there's only an
Then-
oral agreement, Lordship, but
then-
clause 3B is there, Lordship, which covers my case.
Which says what?
That in case of oral agreement, the concerned deputy commissioner has to make this record a statements, Lordship, of the concerned village council as well as the concerned department, Lordship. And basing on the finding of the deputy commissioner, the department can decide, Lordship.
Who is your ancestor? There are two landowners.
Yes, there are two landowners.
What are the names of the two landowners? You're ready, you said.
Yes, Lord.
What are the names?
Lordship, I'll give you the name.
Give us item 6.
Yes, yes, yes. No.
If you'd like to kindly come to page 38, Lordship. Page 38.
Yes,
Page 38, para 5, Lordship.
yes.
That in the year 1960, the petitioner's grandfather, late so and so. This is the petitioner's grandfather who has donated land. And may I continue, Lordship?
Yes, yes.
Donated some acres land to the government for establishment of the office of SDO, PWD RLB, and several other departments under the state government. The land is situated with so and so, which falls under the jurisdiction of so and so, and the same was donated free of cost to the petitioner's grandfather without claiming any land compensation. In this particular estate and in the same vicinity, another landowner, Shri so and so, has also donated a plot of land in favor of the department. Now, when the state government they have filed their affidavit, they are silent on this facts, Lordship.
How does it matter? You see, the
No.
issue is
Yes.
in your para 5 out here. Where is the pleading that the land had been transferred to the government with the condition that there would be appointment given by the government?
Lordship, paragraph 6, Lordship.
Yes, let us.
Paragraph 6.
Yes.
The petitioner backs to state that due to illiteracy and ignorance, there was no written agreement executed between the department and the landowners. Nevertheless, it was orally agreed between the parties in the presence of the village functionaries that by virtue of the land donated to the government, the landowners would be offered opportunity of appointment against grateful post. Even to this averment, Lordship, the state is silent.
Now, you said that to substantiate the stand of the petitioner, the village council has issued a certificate. Where is this certificate? Page?
Yes, Lordship. Annexure B, Lordship.
Page?
49, Lordship. Page 49, Lordship.
Yes.
Page 49. May I read it, Lordship?
Yes.
This is a certificate issued by the village council.
Yes.
Usually made village council.
What does it say?
This is to certify that Shri so and so. This is the petitioner.
Ah.
He is a permanent resident of Mishilimi village. He is the legal land owner of the present Department of Engineering Office, PWD RNB at so and so on the Zonabado district, Lord.
How can he be the legal landowner when you have given something away? When you have given something away,
Lordship.
how can you say that it still belongs to you?
This is
Supposing-
the language used by the village
Supposing you
council,
give a child a sweet, he eats it. After 10 days, can you say, give me back my
The only
sweet?
intention of this content of this letter is that.
But
he
where
was-
is
he was a landowner.
where is the agreement?
Lordship,
Where is the mention of any agreement?
Lordship, your Lordship may kindly come to page number 51, Lordship.
51.
Page number 51. This is annexure C. This 51 is the type copy of a deed of agreement, Lordship.
You said it was oral agreement. How
Lordship,
can it be typed agreement?
yes, Lordship, the contents, Lordship.
Ah.
In the year 1960, there was an oral agreement, Lordship. This is a subsequent development, Lordship. May I read it, Lordship?
Yes.
In addition to the land given in the year 1960, Lordship, due to government free of cost for the then circle headquarters, which has been already surveyed and demarcated by the government, in the year 1975, we, the undersigned GPs, village council chairman, and members as well as the landowners on your all public and concerned landowners of so-and-so village do hereby agree to give as much land as government requires for subdivisional headquarters for various development work under the following terms and conditions. One, the addition requirement of land for subdivision.
That's the additional requirement of land.
Yes, Lordship.
Additional.
Yes.
Your case is not with regard to additional. Your case is with regard to
But this document shows that I have donated, my ancestors have donated in the year 1960, Lordship.
Over.
This is an admitted fact.
That is all right.
Yes, Lordship.
We are not denying that you have
Lordship.
donated. But there was no condition there. There's no proof of any condition there.
My respectful submission before this honorable court is there was an oral agreement, Lordship. And there's a clear provision under the notification in case of oral agreement, Lordship. State government have come up with
That also after your grandfather did not claim, your father did not claim. Where is the right now? Now let us, this is only with respect to additional land of
Yes,
1975.
it is with respect to it. I admit
And
that.
your case is with regard to land given in 60.
1960 years.
So
Lordship.
then- Now,
This also substantiates the stand of the petitioner, Lordship.
no, we are not denying that you gave land. Your
No, I
father
have
grant-
made specific amendment in my pleadings,
let
Lordship.
us see the
Notification.
notification.
Page number 47. Page 47.
Yes.
5th March 2018. May I
Yes.
read your Lordship?
Yes.
In pursuance of approval of the cabinet white OM number so the government of Nagaland is pleased to notify the following policy with regard to appointments to create for posts under the government of Nagaland on land ownership basis. It has been laid down white notification dated so and so that no land shall be acquired.
Dated 26/7/2005.
Five. This
Okay.
is very important, Lordship.
Yes.
This deed is important, Lordship.
Yes.
That no land shall be acquired free of cost. And all land shall be acquired on payment of full compensation as to the
Correct.
migrant.
That is subsequent to 2005.
Yes, Lordship. Yes, Lordship.
Then
No further completion of employment and service or contractual works should be entertained. Therefore, in the case of any department has entered into agreement with the landowners in deviation of laid-down policy on or after 26/7/2005, such agreement shall be treated as null and void. The department concerned shall take necessary action accordingly to nullify such agreement. 1B. In case the department concerned is of the view that the agreement should not be declared as null and void, it shall refer with relevant details giving justification to the Department of Land Revenue for examination and advice and consultation with PNR and Justice and Law Department, and thereafter submit a matter for consideration and decision of the cabinet. 2. All cases where administrative headquarters and block headquarters were set up in various parts of the state on lands donated free of by individuals, villages or people of that area should not be reopened for compensation or for employment in consonance with the policy brought out by OMs dated 26/1977. 3A. In other cases prior to 26/75 and subsequent to setting up administrative and block headquarters on freely donated land, where a specific written agreement exists providing for employment of the landowner, the claim of the landowner for employment should be settled in terms of such agreement. So 3A is in terms of written agreement, and 3B is for oral agreement, Lordship. 3B, Lordship. May I read the Lordships? If there is any claim for providing employment as a result of oral agreement, the department concerned shall refer the matter to the Deputy Commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract of supply orders, has been given in the past. Written statements from witnesses, that is government officials of the concerned department, and district administration and village functionaries present at the time of such oral agreement should be taken by the Deputy Commissioner. 3C says it is clarified it's not a policy of government to provide employment to landowners in perpetuity. Whereas in the case of the core landowner, they have to violate this provision because they have enjoyed more than once. And the exercise of 3B was not taken, Lordship. In case of oral agreement, the concerned Deputy Commissioner has to do the exercise as provided in 3B, which was not done in this case, Lordship.
you were born when?
Lordship, I have to check the record, Lordship.
No, your affidavit will say
Yes.
your writ
My
petition
affidavit.
affidavit. Yeah.
The petition was filed in the year 2024, and I was 25 years of age, Lordship.
Correct. So you were born in 1999.
Lordship.
In 1999, if you were born, And you were nowhere in the picture in 1960 when the property was given.
Yes, I agree, Lordship, I agree. And Lordship, may I also kindly appreciate one fact, Lordship. The department, they have utilized my land for more than 3 decades. And now, after giving the employment to the other coal and
You
owners,
see, the Limitation Act is applicable in the state of Nagaland.
Lordship,
There is a judgment also, I think, Supreme
Lordship.
Court. Now, you have not made a claim for this land. No one. Now you're making for the first time. After how many years? In 2023.
Lordship, may I kindly appreciate a fact, Lordship.
2024. After 64 years, you suddenly, one fine day, you are born and you come up that you should be. Now, how can it be?
Lordship, the first vacancy arose in the year 1988, Lordship. May I kindly appreciate the fact. Because this is the environment of the state government, Lordship. The sole contention is that,
So then, in that case,
Lordship.
a person can make a claim. Your grandchildren can also make a claim if you are not given a job after 200 years also, or 300 years also.
It depends on the vacancy available.
Yes, if there is a vacancy, there will be a vacancy available.
Establishment, Lordship. In the office of SDO, Lordship.
You have to.
RNBD.
Maybe.
No, the first vacancy arose in the year 1988, and that benefit was given to the coal land owner, Lordship. Is that the case that there were vacancies all along, Lordship?
Yes,
As per proceed, we direct them to consider. We find the reasons for the it's very many suddenly conflicting orders. Certain cases, if they cannot establish that they were in oral agreement, then we dismiss.
What has the state government said with regard to this? What is the stand of the state government before the single judge?
Lordship, I was informed that on the basis of land ownership, have already exhausted, has already appointed Lordship.
No, I've already been exhausted.
Lordship.
Now, the only question that we want to know is whether the family, the family from the family of this person, page 38, this family of Visapu Vatsa, if he has been given any appointment.
Lordship, further, I have the instruction.
Okay, right. Adjournment prayer has been prayed for. Adjournment prayer has been made on behalf of the respondent number 5.
For the state, Lordship.
For the state. The matter pertains to appointment to a government post on the basis of land donation. It is the case of the appellant that the subdivisional office, PWD bracket RNB, Pogoboto has been, Zenoboto has been, Pogoboto, Zenoboto has been constructed on land donated by the late Visapu Vatsa and Sri Yehoto, Pustam. It is the appellant's case that that appointments have been given on land donation basis to the family of Sri Yehoto. Pustam. However, no one has been appointed from the family of Visapu Vatsa. Correct? That's the case.
Lordship, yes.
The state respondent shall obtain instructions with regard to the same. List the matter. Give a date. Just that portion only. Next. Give a date, give a date. When do you want, madam? Give a date.
Mr.
Lordships, I may be allowed to mention item 5, Your Lordship. This may, this is after a weekend.
No, madam, wait, let me hear the other side. Yes, who is appearing? Taka Kishu. Yes, what is your case?
My writ petition was dismissed, saying that the petitioner has no locus.
Do you have locus?
My lord, yes, absolutely.
Come to page 13.
Of my appeal.
Where was I reading something? So your case is what? Your case is that?
My lord, my case is that the petitioner's grandfather and 9 others have donated the land for potato seed farm in the year 1966. And that potato seed farm was converted into a sub-divisional agriculture office in the year 2018. And thereafter, a vacant post of Mali fell vacant. And then the petitioner...
No, wait, let us see the agreement.
Type copy of my agreement is page number 45. Type copy of my agreement is page 45.
There.
Agreement of potato seed farm, land acquisition bungalow. It is in the undermentioned persons being the absolute owner of the land here and below, described in the schedule appended to this date, today, the 27th October 1966, 10 hours. In our own free will and without any coercion, since bequeathed to the government of Nagaland in taken our regards to the government. In return, under this scheme, Nagaland government may give first preference, like country works for others, etc.
So where is the question of employment?
My lord,
It talks about contract works, etc.
the word employment is specifically not mentioned.
Then,
however, the word etc. covers.
etc. covers everything in the world.
My case here is that if, because the stand of the state respondents before the learned single judge was that since the agreement was not in consonance with the Rule 11 and 12 of the Rule 11 and 12 of the
rules.
Yes, rules. So that this cannot be considered. That is one. However, my lord, here there was an advertisement. In this case, there was an advertisement for appointment. The petitioner has applied.
Yeah.
The petitioner has applied. But that advertisement was not in consonance with the apex court judgment because that was pasted only in the notice board of the department and not published in the newspaper. So the stand of the petitioner before the learned single judge was that even if his case could not be considered on land ownership, there should be proper advertisement so that he could compete. However, the learners.
No, but then you have applied.
My lord, I have applied.
Then?
I have applied, but my case was rejected on the ground that.
Oh, okay, you were not
Yes.
considered. Okay.
On the ground that my application was delayed. The first question
Was delayed,
arises
it was-
is whether the advertisement was in consonance with the Honorable Apex Court judgment.
No, that
Whether
is,
it was properly published or not.
that you cannot question when you have taken part in the proceeding, when you have submitted your application. Is it your case that you submitted your application on time?
My lord, the case here,
No.
the petitioner was not even aware that there was a advertisement.
Then how did you submit an
I
application?
just submitted it to the SDO Bongro, and then my application was forwarded to the department. And when my application reached the department, the government, it was already delayed. So my contention here is, even if my case could not have been considered on land ownership, at least I should have been given the fair opportunity of competing in the exam. There should be proper advertisement. I should be allowed to compete. However, the learners.
Let us see your application.
My lord, it's page number 51. Annexure is not it is annexure to page 51.
Yes.
To the Director, Department of Agriculture, Kohima, Island, for proportional application for appointment of Mali as STO office Bonglo. Sir, with due respect, I have the honor to state few lines regarding the above subject cited matters for your favor of your current consideration and necessary action, please. That, sir, I'm the great grandson of late such and such of Bonglo village, who is a bona fide landowner of Potato Seed Farm, which lies under your department. Therefore, I kindly request your authority to appoint me in the said place in place of such and such, who retired on 30th September 2000.
Where is the advertisement?
My lord, advertisement is in page number 54.
When did you submit your application? Three 24.
12/3/20.
No. Look at your name. Look at just below your signature. 3/3/24.
3/3/20.
So it's not 12/3. And last date of submitting application is 5/3.
5th March.
So it is within time.
But it was forwarded from Bonglo district
Huh?
and came to the government. Yes, it was forwarded because I submitted the application in Bonglo district, and then it came to the government. It got So that is how my application was rejected.
Where is your rejection?
My lord, may kindly come to page number 60. Page number 60.
Yes.
From the bottom, the second box, that is cell number 10, it is written, one is written, no, 1, 2, 3, 4, 5. The last fifth box, the petitioner's name, it appears it's cell number 2. And it should be matriculate STO Bonglo. In the remarks column, it is.
Oh, you submitted it late. You have written 3/3 below your signature, but you have given it late.
My lord, like I said, it was not submitted directly to the director, but it was submitted through proper channel. That is, I submitted it to Subdivisional Agriculture Officer in Pongro. Thereafter, it was forwarded and it came to the.
You see, Mr. Counsel, this person, I am grandson of Spencer, in place of this, I am Yusumo Mali. So this Mali has not been appointed on the basis of this advertisement. He was already appointed. Last date of submission of application is 5th March. 2 days earlier, you have written a letter that you should be appointed in place of so-and-so. That so-and-so has not been appointed on the basis of the advertisement.
No, he was appointed on the basis of advertisement.
Yeah, then how could he have been appointed on 3rd? And when the last date of submission of application is.
My application is on 3rd.
Correct.
The last date of application for submission of application was 5th of March.
You see, Mr. Counsel, so if you have challenged the appointment of this Mali fellow, this Mali could have been appointed only after the last date of submission of applications. Last date of submission of applications is 5th March. Your application is of 3rd March. How did you know that he was already appointed?
No, my lord, he was appointed on 28/6/2024. The private respondent hearing was appointed on 28/6/2024. Yes. That SMU that I have mentioned is the one who has retired. Yes.
Okay.
Retired. That I have mentioned.
Okay,
is
retired.
the person who has retired.
Okay, retired.
And the private respondent hearing was appointed only in the month of June. That is 28 June 2024.
You see, you have not made any application in terms of the advertisement. You have only made an application for appointment as landowner.
Yes,
that's all.
Because
it's on.
Petitioner was not aware.
Huh?
Petitioner was not aware that there was an advertisement because this advertisement was not properly published.
Let
it
us
was
see.
pasted in the notice board of the department.
Let us see your WPC. Where is it? What have you said?
The advertisement was published, pasted in the notice board of the department only.
Maybe.
So will it suffice? Will it be as per the apex court judgment? That is my question.
Yes, madam. You are ready.
This thing, the petitioner, the appellant is. I'll like to make one clarification regarding this reject list, Your Lordship. In the application, the appellant is making a wrong submission, Your Lordship. His application was not rejected. This
Not
page
rejected.
59, Your Lordship. This is a list of applications applying for appointment to the post of multitasking force.
Correct.
So his application was not rejected.
Not rejected.
In the remarks column, it is clearly mentioned
Yes.
that my application is
On page
rejected because
60.
I have submitted.
Page 60, serial number 2. Right? There's so many 2s. Serial number is, you see the fifth name from the bottom.
Yes, Your Lordship.
Fifth name from the bottom, Nin Sukyu,
Yes,
Yimchungar. Then you come to the last column, genuine applicant, but his application was received after 5th March 2024, which was the last date of submission of application.
That means it is rejected.
This is not the reject list, Your Lordship. This is the list of applicants, Your Lordship. If you see at page 59, Your Lordship.
Yes.
Page 59, Your Lordship, at the top.
No, the applicant, yes. It says list of applicants,
So
but
this is
then
not a reject list.
You see the remarks column.
Your Lordship, if you see page number 58. Your
60,
Lordship.
60.
Now you see another thing. You please come to page 59.
Yes, sir.
You come to 1, 2, 3, 4, 5 from the bottom, page 59. You see the remarks column. Genuine applicant but overaged. What does it mean? Overaged. So he cannot be considered. So his application is correct, but it is late. So you see the issue is this. With regard to the agreement, he has got no case. We do not find any case. There's nothing there. Etc. cannot mean everything under the sun. That's very clear.
If you look at the prayer
But-
of the writ petition also, Your Lordship.
Okay.
His prayer was to appoint him on the basis of land ownership, Your Lordship. And if he cannot establish his legal right as a land ownership, Your Lordship, he cannot challenge the appointment of the respondent.
But now you see he challenges on two grounds. One is on land ownership, which even we agree with you. That agreement does not talk about appointment. It only talks about contract and etc. Etc. doesn't mean everything under the sun. Now number two is with regard to, he says that he wanted appointment under the land ownership, and accordingly he submitted his application. But at that time he came to know that there was an advertisement issued for appointment, and his application was stated to be delayed. He says that he did not submit his application on the basis of the advertisement because he did not know that there was any advertisement. If he had known about the advertisement, then he could have submitted in time. That's what he's saying. And since you all did not publish it in the newspaper, then that is in violation of Mamata Mohanty's case, State of Orissa. That's what his case.
There was no prayer for open advertisement so that he can participate. He was only claiming appointment on the basis of land ownership, Your Lordship. That's his prayer, Lordship. If you look at his prayer, Lordship, he had not asked for open advertisement. He had only asked for appointment based on land ownership, Your Lordship. It's page 41. Your Lordship.
I have prayed for quashing and setting aside the advertisement. My prayer, I have prayed for quashing and setting aside the
So that
advertisement.
on
Yes, but without
Yes.
that, on the basis of.
no, but then you see,
Once
the advertisement has to be published in the papers.
My lord, yes.
You cannot put it in your cupboard and say that an advertisement has been issued, or in the notice board only.
Another aspect, Your Lordship, even in my affidavit, Your Lordship. With regard to advertisement, Your Lordship, page 73 of my affidavit in the writ petition, Your Lordship, page 73.
Yes. Yes.
Para 10, Your Lordship,
Yes.
if I may be allowed to read. Your
Yes. Yes.
That with regard to the statements made in paragraph 18 of the writ petition, the answering deponent states that the condition of advertisement is dispensed with by the OEM dated such and such 3/3/2022, wherein para 2 reads as hereunder. Following difficulties expressed by various departments on account of the fact that in many cases group depots such as chokidars, malis, and tions are filled by landowners or on compassionate ground and locally at the district, subdivision, or village level, the matter was considered by the cabinet in its meeting held on 9 February 2022 and 2 February 2022. In order to remove such difficulties, it is hereby directed that the condition of advertisement is dispensed with wherever such difficulties are faced by a department, as long as a fair and transparent eligibility criteria and process is followed, and in all such cases, approval of the government is obtained. Accordingly, the department exercised the entire selection process after due approval from the government, right, such and such.
My learned friend has kindly correctly pointed out. This only talks about those great for post where there are cases of compassionate ground and for those posts to be filled up by the landowners. So the present case does not fall under this category. My learned friend has rightly pointed out, this is against her.
If they dispense with
This is
it,
against
then
her.
they should advertise again.
No, another thing. This dispensation is only with regard to posts that are to be filled up by land on basis and compassion. This is not the case here. This is normal filling. So normal filling up is not dispensation.
If this has to be considered, then my case has to be considered, not the other private respondent.
And then what was the reason for the single judge dismissing your writ petition?
Single judge has said that I don't have the locus to challenge the private appointment of the private respondent.
Why?
My lord, I'll come to that.
Because there was no agreement.
No, that agreement, though, we agree. We agree with the single judge that that agreement has got given no right to him to be appointed on landowner basis. But with regard to the advertisement for regular filling up of the post, first of all, this exemption from advertisement pertains only to those posts which are to be filled up on landowner basis and compassionate ground. This is not the case here. Your advertisement is for regular filling up, where exemption cannot be applied. And as such, if exemption cannot be applied, then it has to follow the law laid down by the Supreme Court. That's all.
And one of my contention was also that if the private respondent hearing, this is the third generation that they are enjoying. His grandfather enjoyed the post, his father enjoyed the post, and now he is enjoying the post. So this is the third generation.
Who is enjoying the post?
The private respondent's family. The private respondent's family. The private respondent, whose appointment is under challenge.
Okay.
His grandfather was holding the post of Mali. And then after his father held the post, and then now he is holding the post. And that there is an office memorandum by which this is banned.
2018 note.
Yes.
Anyway, that issue has not been gone into. You have not challenged that appointment on that ground, no? Have you taken it in your writ petition?
I have stated that. I have stated.
You have pleaded. Pleadings are there.
Yes.
In the writ petition.
Yes.
That, but then he might have been appointed on merit, not on landowner basis. We don't know. Where does it say?
No, he was not appointed.
If there was proper interview after the advertisement,
We don't know, Mr.
then
Counsel.
we can say that he was appointed.
We don't know.
But there was no interview.
Well,
nothing as such.
how do you know?
Just because
Have they said that there was no interview?
yes, by their document, by looking at their documents, they have selected him.
So he might have got the best of marks in class 10 and class 12.
Yes.
How do you know?
Yes.
And you might have got fail.
By
How
the
do
yes.
then?
Maybe.
So you don't know. Anyway, right? I think, madam. I think the advertisement has to be done afresh to give him chance to participate. That landowner basis, though, he has got no case. You have to. No choice. Heard, Mr. Taka Kichu, learned counsel for the appellant. What do Huh? That's not.
There's no selection process.
No. But it was not advertised in the newspaper. Apple cannot classify 36 of the state of Odisha, what is number 1. That is saying that putting the same hanging the advertisement only in the notice board does not serve the purpose. It is a violation of it has to be advertised in the newspaper. Yes, he did know about it. Yes. Heard Mr. Takakichu, learned counsel for the appellant / writ petitioners. Also heard Miss Ina Holly, learned government advocate for the. Who is for the respondent?
The private respondent has never appeared even before the single bench also.
But
And
notice has
them also a
notice.
extra copy.
Okay, then counsel for the respondent number 1 to 4. No one appears for the respondent number 5. despite service of notice by dusty mode. Further, in the order dated 28/1/2026 passed by this court has held that notice has been deemed to be served upon the respondent number 5. Next paragraph. The appellant has put to challenge the impugned where is that page, judgment and order?
Page 15.
Has impugned order dated 23/7/2025 passed by the learned single judge in WPC 136 of 2024, by which the appellant's prayer for appointment on the basis of land ownership has been dismissed. The further challenge made by the appellant to the impugned order is on the ground that the appointment of the respondent number 5 had been made on the basis of an advertisement dated 26/2/2024, which was only put up in the notice board of the office
My lord, yes.
of the respondent number 4. Correct? 4 or 5 or 4 or 3?
My lord, 3.
3. And the same was not advertised in a newspaper.
My lord.
The appellant who had submitted an application for appointment on landowner basis came to know of the advertisement only later. First off, however, the state respondents had accepted the application of the appellant as an application pursuant to the advertisement dated 5/3/2024 and had rejected the same on the ground that had been submitted late. First off, next, the learned counsel for the appellant submits that the advertisement that had been issued by the state respondents for appointment of multitasking staff (MTS) and one post of tractor handyman under the Department of Agriculture, Government of Nagaland had not been advertised in the newspaper,
My lord.
which was in violation of the decision of the Supreme Court in the case of State of Orissa versus Mamata Mohanty, reported in 2011,
Volume 3, SEC
SCC
436.
433. He accordingly submits that the advertisement dated 5/3/2024 calling for filling up the vacant post of MTS and one post of tractor handyman.
My lord, sorry for interruption, but the advertisement dated is 28 February
Oh.
2024. Or 26
26 February, not 5/3. 26 February 2024. 26 February 2024. Not being made in terms of the decision said so. The same is the same not being advertised, the same is in violation of Article 14 of the Constitution of it. Ms. Inaholi, the learned government advocate, on the other hand, submits that there is no infirmity with the impugned order passed by the learned single judge in dismissing the writ petition on the ground that the claim for appointment to a regular government post on land ownership basis is made on the basis of a agreement pertaining to. What is that agreement? Page. Agreement pertaining to a potato seed farm. Is it?
My lord, yes, potato seed farm.
Which was donated by the appellant's father or grandfather,
In nine.
and 9 other persons for establishment of the subdivisional agricultural office Pungro. Correct?
My lord, erstwhile it was potato seed farm, now subdivisional agriculture office. In 1966, it was established.
Okay, by our seed farm, which is now converted into
Subdivision.
the subdivisional agricultural office Pungro. She submits that the agreement entered between the landowners and the government provided that the land had been donated on the condition that first preference would be given to the landowners for contract works, etc. He submits that the word inverted commas, etc. does not include appointment to a government post on landowner basis. She also submits that when the advertisement for appointment of multitask MTS had been made, on 26, when was it? Made on page 26/2/2024. And the last date of submission of application had been fixed at 5/3/2024. The appellant's application for appointment dated 3/3/2024 had been taken into consideration. And he was not selected, and the appellant was not selected.
The application was before the screening committee.
And the
It was screened
application.
by the screening committee.
No, and the application of the appellant was not accepted by the screening committee. Why? On what ground?
No, I'm saying the application of the appellant was also before the screening committee. It was not
Correct.
this application was not rejected. It was not before the screening committee.
Before the screening committee, okay. She submits that the application of the appellant had not been rejected on the ground that the same had been submitted beyond the last date of submission of application, that is 5/3/2024. The application of the appellant, the application of the respondent number 5 was accepted by the screening committee as he was found to be more meritorious than the appellant, correct? Or he was not found to be meritorious, but
Based on the documents.
based on the documents which were examined by the screening committee. Based on the documents of the candidates by the screening committee. She accordingly submits that there being no ground to interfere with the impugned order, the appeal should be dismissed. We have heard the learned causes for the party. The claim of the appellant for appointment to a regular government post is on 2 grounds. Firstly, on the ground that he being the son of a landowner, and none of the family of the landowner, namely, who's their father, grandfather?
Grandson.
No, grandfather's name?
Late Nokokyo. Late Nokokiu. Nokokyo.
Not having been appointed to any government post, the appellant should be appointed on the basis of the agreement made between the landowners and the government. Secondly, the appellant had not submitted his application on the basis of the advertisement dated 26/2/2024. Due to the fact that the advertisement had been hung up only on the notice board of the office of the respondent number 3. If the same had been advertised in the newspaper, in terms of the judgment of the Supreme Court in Mamta Mohanty Supra, how the appellant could have submitted his application for the set for consideration for the set post on time, within the time prescribed. Gustav. Due to the respondents not advertising the vacant post in newspapers, the appellant could not be considered for the vacant post on merit, as his application had been rejected on the ground that it had been submitted after the period of after the last date of submission of the applications. Next paragraph. On perusing the agreement for the potato seed farmland made between the appellant's grandfather and others on the one side and the government on the other side, we find that the agreement only, we find that the land has been donated only on the condition that the landowners would be given first preference in contract works, etc. We do not subscribe to the submission made by the learned counsel for the appellant that the word etc. would include employment to a government post. The word etc. would have to derive its meaning from the previous word mentioned in the agreement therein, which is contract works. As such, we hold that the appellant has no right to appointment to a regular government post on landowner basis in terms of the agreement entered into between the landowners and the government. Next paragraph. With regard to the second issue as to whether the appellant should have been considered for filling up the 19 posts of MTS and 1 post of tractor handyman in terms of the advertisement dated 26/2/2020. We find that there is no dispute with regard to the fact that the said advertisement But we do not know actually whether he's did because. So are you saying that he knew about the advertisement or he did not know about the advertisement?
He knew, Your Lordship, that's why he tried to submit it before the timeline, Your Lordship. That was 3rd of March, and the timeline was 5th of March. Your Lordship.
Did you publish in the newspaper?
Did Your
No.
Lordship?
Then. What was it?
Should have been considered. Totally not provided details of NGS and what was the capital in terms of the advertisement dated 2016-2024. We find that there is no dispute with regard to the fact that the safe advertisement
Had not been published in any newspaper. And the same had only been hung in the notice board of the office of the respondent number 3. Next paragraph. In the case of Mamata Mohanty Supra, the Supreme Court has held that as a vacant post should be published. Vacant posts to be filled up should be published in newspapers. Besides notice boards. To enable those persons interested in applying for the post to apply for the same, to apply for the same, or else it would be as the absence of the same would be violative of Article 14 and 16 of the Constitution. In the above case of Mamata Mohanty Supra, the Supreme Court has held at para 35 and 36 as follows. 35, 36? 35 and 36. Next para. Though the appellant had submitted an application for appointment on 3/3/2024. The appellant had submitted an application for appointment on landowner basis. On 3/3/2024. In place of one Mr. Yesumiud Mali. SDO, how SDO? What SDO is a subdivision agriculture office.
My lord, yes.
How can you be appointed in this place?
In the under the establishment of STO, under the establishment of subdivisional agriculture officer.
Post of MTS Mali. The post
Okay.
is-
Paid for
Yes,
both.
you money.
Okay. Mali is the name of the post.
Paid for both, yes, my lord.
It's like you can name only.
I thought it was the surname or something like that.
Yes, you Mali.
You put comma in between the names at least. What have I said?
Sorry.
SMU, comma, who was a Mali who had retired on 30/9/2023. There is nothing to show in the said application dated 3/3/2024, comma, that the same had been made pursuant to the advertisement dated 26/2/2023. Full stop. Though the respondents have taken the application of the appellant to be an application made in terms of the advertisement dated 26/2/2024. The same does not appear to be the case herein. Full stop. In any event, next para, in any event, without going further into the issue, the fact remains that the advertisement dated 26/2/2024 had not been advertised, had not been published in newspapers to enable all interested persons, including the appellant hearing, to have a chance to compete in the thing. Accordingly, in view of the said advertisement being in violation of Article 14 and 16 of the Constitution in terms of the judgment of the Supreme Court in Mamata Mohadi Supra, we find that any selection and appointment made pursuant to the said advertisement dated 26/2/2024 is also illegal and in violation of Article 14 and 16 of the Constitution.
In specifically
In
with
respect to the previous model. Because
stop.
here. many posts.
And next, this finding of this court is specific to the selection and appointment of the respondent number 5. So accordingly, in view of the reason stated above, the appointment, the selection and appointment of the respondent number 5 in terms of the advertisement dated 26/2/2024 is hereby set aside. The Directorate of Agriculture shall publish a fresh advertisement in the newspaper to enable all,
specific with regard to SDO, Pomro and.
with regard to SDO,
It's in the
with regard to the post of Mali in the office of the SDAO, Pungrov. What have I said? Hello? Newspaper, to enable all interested persons, including the appellant and the respondent number 5, to apply for the same. The same should be done at the earliest. Consequently, the impugned order dated 23/7/2025 passed in WPC 136 of 2022 is hereby set aside.
But the future time, specific time.
No, let them take that time. Okay, within a period of period should we give?
In order to be more specific, my lord,
No.
because the state may take advantage of the statement pending like that.
We'll set aside, that's one. If they continue, then you file a contempt.
My lord, yes.
Acha, one thing, should we mention about the exemption application? Is it required? You want us to mention this?
Regarding
But this,
You are page 73.
17.
73. That OM 3322.
It should be so late because now we've already decided.
No, but you have got to understand
Yes.
that page 73 OM, that is exemption from advertisement, is only meant for posts which are to be filled up on land ownership basis and compassionate ground.
Because
This-
I'm not relying on that.
Okay.
much of it.
For admission, item number 1.
So
Made this my lordship. Lordship had now said that today seems to be the day of our land owner cases. And this, my recent case also is landowner appointment. Lordships, I humbly beg my lordships that outside the purview of my case, this land ownership appointment that is being practiced in Nagaland, lordship, those who, after 2005, lordships have already conversant that no appointment shall be given except on payment of compensation that is already passed. So after 2005, that is another case. But prior to 2005, lordship, since there is a scheme in general, lordship will kindly appreciate that this case comes after under Article 371A that is provided to the state of Nagaland. And in matters of grade 4 appointment, lordships will kindly appreciate that all grade 4 appointments.
371A is with regard to what? Customs. Then?
Yes, the land pertaining to land.
Government job has got no connection with customs.
That is also true, but somewhere on the line, lordship, it has come as a practice. And my lordships will notice that all those landowner appointments, claiming landowner appointments coming before this honorable court, the other party, grade 4 appointments are all done through backdoor because still they.
Madam, we all know that.
Yes,
now,
yes.
Let us get to the crux of the matter. What is the issue?
My issue here is I am the landowner of subdivisional office Atoizin PWD RLB. This is the issue here. Subdivisional office.
You are the landowner or your grandfather was the landowner?
Grandfather lordship.
Grandfather?
Yes, in 1984.
In 1984, your grandfather gave land for this office with anybody else or himself? His own land or?
There are three.
3 persons.
3 persons, and the respondent government has already issued a map regarding the land on 3 individuals. That is from Chopini clan. Subdivisional office is the donation of Chopini clan. Lordship will kindly appreciate.
Subdivisional office PWD
is the land. Chopini clan is the landowner of subdivisional office PWD RNB. IME clan is the landowner of executive engineer PWD RNB office. That is the distinction. And there is no dispute between the 2 clans because in between the 2 offices, there are about 2 kilometers apart. So there is no dispute between
So which land did your grandfather give?
I am Chopi.
Yeah, Chopi.
I am Chopi clan lordship. And the respondent number 5 is neither landowner. It is admitted in his own affidavit.
So, madam,
yes,
basically, the Chopimi clan has given the SDO office.
Yes, lordship.
They have been appointed.
There are three landowners. One is already appointed. That is
from which clan?
What I am saying is one is already appointed. The one landowner is already appointed. That also by approaching this honorable court, lordship.
Whatever.
Lordship. The other one that the respondents are claiming, both the respondent government and the private respondents are claiming that.
Madam, let's be very clear.
Yes.
There are 3 landowners. One landowner is the Chopimi clan.
Lordship.
The second clan is the IME clan.
No. IME
is E.
Okay, there is no dispute between the
Chopimi clan has given the SDO's office. Correct?
Yes.
Now
that arises.
Now the SDO's office Now, in the Chopimi clan is made up of how many families?
3 landowners.
3 landowners.
Three landowners. Lordship will kindly peruse the map.
No. Then tell me the 3 landowners' names.
Yes, 3 landowners. One already got, one landowner
Name, madam, name. A, B, C, Apple. Orange.
Hinoto X.
Hinoto. Then?
One landowner, Hinoto X already appointed after approaching this honorable court. Now the second one is Hinoto X approached this honorable court to get that.
What do you mean X? X is what?
X is his father's
Okay.
Only Sini
Okay.
knows how to pronounce Lordship. The master tribes. X.
Okay.
So
Then
Hinoto, one landowner
appointed.
appointed.
Then
The second one is the dispute. I'm saying that there are 3 landowners from Chopimi subdivisional office. One is Srimati Bokatoli. They are claiming that 2 appointments already given, but Srimati, I'm praying before the honorable court and submitting before the
madam,
honorable
please
court.
complete your sentence. In the middle of your sentence, you're jumping to another sentence, then prior to finishing that, you're jumping to we are getting confused.
Okay.
Ah.
Lordship, so 1 appointment already. The second appointment, both the respondent government and the private respondent, though he doesn't have the locus standi to caution me. The second appointment is Bogatoli is not a landowner appointment and from general category. So only this has to be settled, Lordship. My Lord will kindly come to Bogatoli's, which we are disputing. Otherwise, there is no dispute that between the 2 clans, and post that arises out of the offices. Subdivisional office post belong to Chopimi clan, and grade 4 post that arises out of executive engineer office belongs to Ayami clan. That is okay, Lordship. And both have no dispute. Now, my Lord will kindly come to, this is the dispute. My Lord will kindly come to page 27.
Who is for the private respondent?
Your Lordship, I am representing the respondent number 5. Your Lordship, here, they have already received 2 appointments.
I'm saying no.
I have filed a compliance.
So anyway, she has agreed that 1 appointment is there already.
2 appointments.
No, according to you, 2. According to her, 1.
Yes.
Now, so that 1 is enough.
No, Lordship.
Why should why should there be more than 1 appointment?
Lordship, because 3 individuals donated the land.
3 individuals donated.
Yes,
that is
from
what
Chopimi clan.
That is why I have asked you from the very beginning. What are the names of those landowners?
Yes,
who had donated the land?
Lordship, you kindly.
May I take your Lordship to the report of the government, page 75 of the appeal memo. 75.
That will be. Lordship is on mine or on his.
We are neither here nor there. We are still lost, trying to find our way. What we can do, madam, what we can do is we can take this up tomorrow.
Lordship.
Because we have to do the single bench and we have got some matters.
Your Lordship, tomorrow I may have some difficulty because I have some fixed matter in the other courts.
Which courts?
A long time fixed matter in the district court, Your Lordship. I have an argument.
I also have, Lordship.
Okay.
Tomorrow I have some fix.
Okay, we'll admit this appeal. You have a hearing on some other date.
Your Lordship. If not, it's a very simple matter.
Lordship, one aspect is that this has been filed some months back, and
she's not making it simple. It's complicating.
Yes, it's complicating us. We are still trying to find out where we are.
Otherwise, Lordship, I will just come to the pinpoint. Lordship can just decide. It's either, if I cannot prove myself that I am the landowner, the responsible.
Let us see the report. Page.
Your Lordship, the report is at page, starting from page 74. Page 74. By the direction of this Honorable Court, that this report was prepared by the District Administration Appraiser Subdivision. And this was placed before this Honorable Court. We take a Lordship to para 5 at page 75.
Yes.
Oh, perhaps starting from para 3 will be more clear.
Wherever. Huh.
Appointment of Sri Hinoto X and Srimati Bokatoli Simi. It was noted that Sri Hinoto X, son of Khehevi Choki, and Srimati Bokatoli Simi, daughter-in-law of Nitovi Choki, has been appointed based on land donations by Sri Otoi's family for the establishment of...
Otoi is the petitioner, the appellant here.
Yes, Your Lordship. Establishment of SDOP WR and BR2 division. These appointments were made in accordance with prior recommendations by his family contradicting the petitioner's current claims. Then, Your Lordship, the para 4. Decision regarding the petitioner's eligibility. Based on the findings, it was concluded that Sri Otoi Simi cannot be recommended for the post in question as his land ownership claim has been disproven and previous family recommendations have already been honored with the appointment of Sri Hinoto X and Srimati Bokatoli. In light of these facts, the petitioner's current request for appointment cannot be considered further. 5. Admission by Sri Otoi V. Jimomi, or Sri Otoi V. Otoi Simi regarding his petitions. On several occasions during the inquiry, including those in the presence of the executive engineer, the subdivisional officer SDO, and other officials and landowners at the ES's chamber, ADC office, Atoizu, Sri V. Otoi Simi admitted that he had not written the petition to the aforementioned officers. This admission casts significant doubt on the validity of his claims and petitions. Then the table, Your Lordships.
What is this? What do you mean this had not written he had not submitted the petition? What is this petition?
These are petitions to the officers, Your Lordship.
How does it matter?
Yes, Your Lordship. Now the table, Your Lordship.
Yes.
One is Khehevi, against which Hinoto X has been appointed. Second is Nitovi Choki, son of late Khehevi Choki, where Bokatoli has been appointed. And one is Hovshe Choki. So even if we look at this, Your Lordship, in fact, going by the submission of my learned friend, Madam, Your Lordship, Otoi's father is Vitoi.
Just a minute. Who is who? Huh? Her father?
Yeah, the appellant's father. He is also the petitioner. The appellant's father is not even in the list, Your Lordship.
Oh, his parents' father is not here.
Yeah, he's not here.
But is the show?
But he's in the part of the family, and the respondent number 5.
Huh?
Respondent number 5 is also a clan member.
Nitovi Chopi.
And we have submitted complaint since 1984, Lordship. It is here.
No, Your Lordship, not grandfather. It's actually the younger brother of Nitovi Choki.
So this lineage.
Here, the younger brother of Nitovi Chopi. Her grandfather is
my
her
father.
client's father is the younger brother.
Appellant's
father is the younger brother of Nitovi Choki.
So he's got no claim.
But rightfully he is also from Chokimi clan, and I may not be in the direct family, but I'm also from the clan of Ayemi clan, and Ayemi clan wanted to recommend my name.
You are who? You are this Bokatoli.
No, I'm respondent number 5.
Who is the respondent name?
Respondent number 5 is Otoka Aye. Ayemi clan. I belong to Ayemi clan. Ayemi clan.
So Ayemi clan is a different thing. Ayemi clan is with regard to the ease of it.
My appointment is challenged by her. That's why.
Yes. Because
how can you challenge?
He was appointed in a post, beyond post,
in the SDO office.
Yes, that is the issue.
That is my claim, Your Lordship. State disagrees with that.
Okay.
The state will say. The state disagrees.
Okay, let us see. State says respondent number 5 appointed where?
Respondent number 5. Welcome to this. Please appreciate this.
how Bukatuli was appointed. So the question, Bukatuli, he was appointed under recommendation of the
Landowners.
And I have marked.
You're not the landowner, madam. You're
I have marked.
you're the niece of the landowner. Niece. Sorry, nephew.
Lordship, the person I have marked is the petitioner, the present appellant.
Acha, go to each of you. The person who donated.
Present appellant.
A present appellant.
Appellant in this.
Oh, the present appellant has also, yes.
Present appellant, Lordship.
You have, it seems that you have recommended Bukatuli and Hinoto.
Lordship, that was before approaching this honorable court. This Bukatuli also approached this honorable court.
Okay.
Bukatuli, Lordship.
Okay.
Just a clarity.
Madam, thank you for being so truthful and frank. Now, what remains? You have recommended, and they have said, okay, agreed, done, approved, and given appointment as per your wish.
Lordship, here the recommendation that is being given, like in the case of the respondent number 5. He is neither a landowner. He's not a landowner, but he happens to be from Ayami clan in general. That's why he was appointed. He never fell under the landowner scheme or under the compassionate appointment scheme. And respondent number 5 was appointed through backdoor. It is admitted fact that...
Madam.
Admitted fact.
Madam, look at your cost title. Your cost title shows that the respondent number 5 is a peon in the E office. In the office of the E, not in the office
appointed.
of...
That's why, that is the dispute. So, my lord, I will convince my lordship.
No, what do you mean that is the dispute? You're interested in the SDO's office. You're not interested in the E office.
The lordship, the office of the executive engineer is donated by the IMA clan.
Correct.
So IMA clan has issued no objection certificate to the authority, saying that a prison respondent number 5 can be appointed.
Correct.
So under passage it was
No, that is all right. So that is why I'm asking her, why are you disputing or challenging the appointment of the respondent number 5 to the office of the E?
Lordship.
You want to be appointed in the office of the SDO.
Lordship, sub-divisional office is under the EE office.
That way, the district education's office is also under the office of the directorate. Everything is like that. The issue is whether the office are located on the same land.
Not on the same land.
Then?
The Lordship, my lord will kindly come to page 27. I will satisfy my lordship. Here it is very complicated. My lord will...
You said it was very simple. You'll pinpoint the problem, and now we thought we'll land in Dimapur. Now we have gone to Mon. Then we have got to turn our car towards Dimapur now.
You'll find the appointment of the private respondent number 5 in serial number.
And you are giving all loose sheets.
He was supposed to
give a copy also to him, to your colleague.
And my lord, all this is being submitted to this honorable court is supplied by the respondent number 5. That's why there is a dispute.
Madam, that is all between you.
I have a conference with the concerned department, officials of the concerned department.
No. She's saying that you have a conference only with respondent number 5, nobody else.
That is his solution, but I had a conference with the department.
I honestly asked the concerned officer as to where you are going to supply the documents to the government advocate. They say that the respondent number
Five at
supplied
eight.
to them.
Ah.
It's a public document, appointment order.
So
anyway.
all the orders are being issued from your chamber. Huh?
Lordship, that's a very unfortunate allegation.
I don't
All the
know.
list sheet submitted is part of this petition only, Your Lordship.
Okay. It's part of the petition.
Yes, Your Lordship.
We don't know. So what do you want me? What do you want to show me here? What do you want to show me? You've just given me this 3 pages document now, which
Respondent name is reflected in this is one co-appointment. One co-appointment.
okay.
And 39 appointment in one co made by the authority of the state. Respondent number 5 is in serial 24.
Yes, madam. What?
No,
Only one question we'll ask. One question. Please answer. This respondent number 5, is he appointed in the office of the EE?
no. The office peon of a subdivisional office. That's why I'm before this honorable court. Otherwise, why should I come before this honorable court?
We don't know. That's what we're asking.
Yes, that's why I'm trying to clarify. before this.
So how do you prove that the respondent number 5 was appointed to a post belonging to the SDO's office? How do you prove
Page
that?
27.
27. This letter serves as an official confirmation that I, Hokivi Sema, is employed under PW DRDB office. Who is this Hokivi Sema? Respondent number 5? No.
It is his post. It is his post. He was promoted to DAF 3.
Who is this Hokivi Sema?
Hokivi Sema, the person who was serving as peon.
Okay.
He was promoted to DAF 3, and this vacancy under PWD
This one, she's relying upon this document.
subdivision. He is still in service, Lordship.
Madam, this is not even an official document. It's written by some Hokivi Sema, not even a party here.
No, Lordship, he is the peon in this post fell vacant. This post fell vacant due to his promotion.
Madam, how? Yes,
And-
there is nothing here. This is a letter written by some private individual, some person. This is not an official document. There's nothing. How can we rely upon
That's
this?
why, Lordship, we
Was
need the
not even part of
interference.
the writ petition, Your Lordship.
Interference.
This was not even part of the writ petition. Your Lordship.
Not part of the writ petition.
I file it. I file it, Lordship.
No, whether you filed it or not, whether we can take cognizance of this. You see, this is a document, not even an official document under the Evidence Act also. Now, how do we know this is a truthful document, not an official document, nothing?
Also 28, Lordship.
Huh?
Another employee
Huh?
who were serving under subdivisional office. At least, Lordship, these are proof.
You go to the civil court and prove these documents. How can we take cognizance of these documents unless they agree to it that yes, it is correct? Difficult, madam.
Lordship, here, the Gauhati Joint Council then, page
Look,
29. Page 29.
the impugned judgment was passed on 9th June 2025. And your letter has been issued on 7th June 2 days prior to the judgment.
That's why.
That's
I
why what?
place it before this. I place it before this honorable court.
Let us see, where is it in part of your writ petition? Where is it part of your writ petition? I doubt it's part of your writ petition. 2 days prior to the judgment.
Lordship, I place it before the honorable single judge at the time of hearing. And there is 29, page 29. At least, Lordship, here my only submission before this honorable court is I want to take my lordship to Bogatuli's appointment and his application, but we are as jungling up. Whether that is land honor post or not. At least give me that opportunity
Madam, you see,
present myself.
You see, madam, the problem is this. This is a writ court. This is not a court of facts. a report has been made by the Office of the Additional District Magistrate. Now, this report, if you say that the contents of this report is incorrect, then you have to make a challenge to this report. Have you challenged this report?
Lordship, I have not, but I have filed affidavit, counter affidavit against this report.
So,
The direction given by.
so what it means is that there is a dispute with regard to facts. Which is the correct fact? Whether the report is correct or that is your affidavit is correct. We do not know. You go to the civil court and prove your case by way of evidence then. How can this writ court decide whether your submission is correct or his submission is correct? Should we go by the way he looks, by the way he walks, or by what? What should be the basis?
Just one aspect, Lordship. My one humble submission. Lordship, in land owner appointment, those land owner appointment scheme is only for those who donated the land themselves. That is one aspect. There is no question of recommending. I am not a landowner, but I am Jimomi going and asking for recommendation and appointment that is illegal. Landowner scheme is not provided under such circumstances. So here my only question is, if I cannot prove myself as the landowner, just before this honorable court, honestly, I'm just praying before this honorable court before the single judge also, I brought this topic up. He is not a landowner, and that he has already admitted in his, the respondent number 5 has already admitted in his affidavit in opposition.
He belongs to that clan, IME clan.
No, but not just because I
Madam, this is not a PIL. A writ petition is where the first requirement of a writ court to see is, in a writ petition, whether the petitioner has some right which has been violated. You have got to prove that first. Then you can go and attack the others. First of all, your right, your locus has to be established. You cannot file a writ petition and start attacking others. You have got to say, this is my right, this right has been violated, and the consequence of that right violation is this.
Lordship, here before this honorable court, I have the Deputy Commissioner's recommendation.
Madam, I think it's enough. We have heard. There's nothing. We have given you enough time. We're going round and round. Like a Hindi movie, all the love songs are running around a tree now. Right.
Lordship, just one humble submission.
Yes.
He is not a landowner. That is admitted fact in their affidavit in opposition. I'll pray before this honorable court, as my lordship has already passed. He was appointed through backdoor. That's why quash his appointment order and make general advertisement. At least whether I am a landowner or not, I have all the documents I have annexed here.
No. You have to show locus. You've got to show the locus. We cannot do that. You've got to show that your right has been violated first.
Lordship, I have the ADC certifying me that I am the landowner. I have the village council certifying me.
Madam, you yourself have just admitted that you are the niece of the landowner.
Lordship,
And also that the very fact that it is you who has recommended this Bokatoli Sumi. And now with regard to respondent number 5, he has been appointed against a post in the E's office, though you are saying SDO office. Now that has not been proved for the simple reason that the document that you have submitted, which is part of your appeal, is just 2 days prior to the judgment in order, which cannot be a part of the writ petition. Because your writ petition was filed in 2024 and the document that you have submitted in the appeal is of 2025.
I place it before the single judge, Lordship. And there is Vic Joint Council stating that we served under.
Heard Ms. Z. Zimomi, learned counsel for the appellant. Also heard Mr. Learned additional
Senior government.
Senior Government Advocate. And third, Mr. Joshua Sheki, Learned Counsel for the respondent number 5. The present appeal has put to challenge the impugned judgment and order dated 9/6/2025 passed by the single judge in WPC 6/6/2024, by which the appellant's claim for appointment on land ownership basis has been dismissed. The petition, the appellant's case is that the office of the subdivisional, no, the claim is that the existing subdivisional office of the PWD bracket RNB, comma, Atois, or what is, how do you pronounce? Atois, ATOIZE, was built on the land donated by the Shopi clan, which, and more particularly, 3 persons belonging to the Shopi clan who were Zuhevi, Nitovi Shopi, and Hovishe Shopi. Page 75, the names are there. Most of it. When the appellant claimed appointment on land ownership basis to the post of peon in the office of the SDO PWD RNB, the respondent number 5 was appointed by the impugned by appointment order dated 13/1/2023. The appellant's further claim is that though the state respondents had apparently appointed one Hinoto X, son of Zuhevi, and Bokatoli Sumi, daughter-in-law of Nitovi Chopi, against landowner on the basis of land ownership, the said Bokatoli Sumi, daughter-in-law of the said Bokatoli Sumi, was not a member of the Shopi clan. Is that her case?
Her appointment
Was not, Your Lordship.
Not a member of the Shopi clan.
Yes, but as a daughter-in-law, they recommended.
Anyway, no. As such, the said Bokatoli Sumi could not have been appointed on land ownership basis for a post in the SDO PWD RNB at 12.
Lordship, I humbly pray, allow me to prove my locus.
No, we've heard, madam. Right, next.
Respondent number 5 was appointed through paper.
Maybe backdoor or not, the issue is that whether it has been done as per the documents here, that's all. We cannot go beyond that. Otherwise, you withdraw this appeal and you file a civil suit, because these are all disputed questions of fact, madam.
Then allow me to withdraw the writ appeal.
Okay. So, Miss, after hearing the matter for some length, the learned counsel for the appellant prays that she may be allowed to withdraw the writ petition, the writ appeal, and make a challenge to the report, report dated 18/10/2024 made by the Office of the ADC and Additional District Magistrate, Government of Nagaland, and various documents which have been relied upon by the respondent.
Also allow me a civil suit.
No, you go,
To
you
dispute
go.
the-
She submits that she would like to make a challenge to this, to some of the documents, as there are disputed questions of facts involved.
Exactly.
The counsels for the respondents submit that they have got no comments to make on the prayer of the appellant. First up, the prayer of the appellant is allowed. The writ petition, the writ appeal is dismissed as withdrawn, with liberty being given to the appellant to challenge the veracity of some of the documents before the appropriate forum as per law.
I will please.
For orders, item number 2.
What else can be done then? Item 2, yes, there is a 94-day delay.
Correct.
So who is appearing for the other side? Any objection to the delay being condoned? 94 days.
Delay, I have no objection, but the appeal is a fit case for dismissal, Lordship.
Okay, we'll hear that.
Taken up tomorrow. I'll take.
Okay,
10
okay.
minutes.
Lordship, in fact, the counsel who is appearing, who is actually handling this matter, my colleague, Mr. K. Ngame, Lordship, for medical emergency, he is not available for a week. I'm extremely sorry, my lord, if this matter can be listed after a week, after condoning the delay.
The claim is against my lord, Mrs. Well,
Yeah.
So Lordship will be sitting for another 3 weeks.
Correct. But he's having some medical emergency.
On health ground, I have not.
That is the problem. That is the problem.
Otherwise, the bill is not maintainable. The fit case for rejection.
Anyway, we'll allow we'll condone the delay first. Okay, right. I heard Mr. N. Angami, learned counsel for the appellant, who submits that there's a delay of 94 days in filing the appeal. Mr. C.T. Jamil, learned senior counsel for the respondent. No, there are 2.
Yes, respondent number 1.
1. And who is for 2? Okay, and so for 2, submit that they've got no objection to the delay being condoned. On the prayer of in view of the concession made by the counsel for the respondent, the delay of 94 days is condoned. Then in the appeal, you write, Mr. N. Angami appears for the appellant and submits that his colleague, Mr. K. Angami,
Yes, ma'am.
who is the leading counsel in this case, is having some medical emergency and has prayed for adjournment. Mr. C.T. Jamir, counsel for the respondent number 1, and Mr. Shekhi, learned counsel for respondent number 2, submit that they have got no objection in
There is another IA suspension is also pending.
We won't pass any order on this. Submit that they've got no objection to the adjournment due to medical grounds. Accordingly, come on, list the matter. After 3 weeks. After 3 weeks.
And the
On,
Yes.
Yeah, please, Lordship. Lordship, I pick to mention item number 2. Here, I'm yet to file affidavit pertaining to the spot notification.
What is this? What's happening? You all are not doing anything. It's the order has been passed long time back.
Yes.
Then
So last time we were given.
last time you pay cost or what? It's a simple thing. Just have to just make a report, that's all.
Lordship.
Mr. L. Iralu. No, Mr.
Imsong.
Sorry, Mr. I. Imsong, sorry. Iralu will be this side. Mr. I. Imsong, learned counsel for the state respondent, submits that last chance may be provided for making the on-site inspection report as directed by this court. Accordingly, accordingly, last chance is provided to the respondent to submit their on-site inspection report of the damage caused and the extent of the same, along with the estimates for the damage, if any. List the matter on, give a date.
Up to 2 weeks, Lordship.
Give a date. Yes, madam, Mr. Date. After 3 weeks. Okay, Mr. Moim Chin appearing for, Moa Jamir appearing for the response number 7 to 9. Submit that affidavit has been filed.
Lordship, 6 April.
9th. 6th April. Okay, 6th April.
Sir Lordship, I beg to mention item number 1. I'm appearing on behalf of Toshi Temjin. Your Lordship, the main counsel is undergoing medical treatment, so I beg for this honorable court to kindly list the name after 3 weeks' time.
What are the names of the 2 landowners? You have not read the file.
Yes, Your Lordship.
Okay, who is undergoing treatment?
Toshi Temjin.
Okay, right. On the prayer for adjournment made on behalf of Mr. Toshi Temjin, Pongan counsel for the petition who is undergoing medical treatment, list the matter. Give a date. Date 9th April.
Lord, I beg to mention, hearing item 10 and 11. As directed by this honorable court, by order.
Yes, application for implement.
Yes, ma'am. I find my IA on 10th February. However, due to some defects in the IA, it was rejected. So thereafter, I've taken it back and then corrected and sent it for waiting. So I'm waiting for the signature.
How can you make a mistake in an application for implement? It is such a.
Now, within a week's time, I will be fine.
How can you make a mistake?
Send it for me. Some defects.
How can there be a defect? It is such a simple application.
Yes. But it's will be done within a week's time. Yeah,
Mr.
LD Sankam, additional.
LD Sanktam.
Yes.
Learned counsel for the respondent. The respondent submits that the affidavit for implement of the village council in terms of the order dated 20/11/2025 had been made earlier. However, the same was under objection. He submits that the said application has been sent for vetting and correction. List them, and that it will be filed within a week. List the matter after 10 days.
Corresponding number 10, item number 10.
You want your name?
Lordship.
Miss
Apila Sankam.
Apila Sangtong appears for respondent number 10.
And item number 11, respondent number 9.
And in WPC 236/2023, she represents respondent number 9. So in the first one, and item 10 will be WPC 321/2023. Just put the writ petition numbers.
Please, Lordship. Lordship, I beg to mention item number 3. I'm making a mention on behalf of whatever is for the respondent board. Lordship, since King Council is in disposal, please matter will be adjourned for next week.
My lords, am I audible?
Yes.
I appear, my lords, on behalf of the petitioner. I just wanted to point out one thing, my lord. On the last occasion, they have furnished me a copy of the affidavit in opposition, and therein they have annexed the performance report in page 4. But perhaps inadvertently that has not been annexed in my copy. Perhaps even in the court's copy that is absent.
Okay.
So they need to furnish us that, my lords. Perhaps an additional.
So your contract was terminated.
Yes, my lords, my contract was terminated.
Is there any arbitration clause?
My lords, there was to my knowledge, but that time has passed. So we cannot invoke that right now. That is the issue.
Time has passed?
Yes, my lords. My lord, there is an arbitration clause, my lords.
Then is there a time period within?
Yes, my lords. Yes, my lords. Within 60 days of the receipt of the appointed. Just a minute, my lords.
Page.
Page number, my lords, would be page number 33. Page number 34, my lords.
Yes.
My lords, clause 64, subclause 3, A1.
A1.
And my lord, the arbitration clause can be invoked only in that within 60 days, my lords, as per my understanding. So that has already lapsed. So
60 days from what?
In case of any disputes, my lord, that would have arisen.
Where does it say that?
My lord, in page number 33, they have stated the contractor would be governed by the provisions of the Payment of Wages Act, Workmen Compensations Act as provided under GCC 1998 edition with up-to-date amendments. Then the next page, my lord, clause D, they say the place of arbitration would be within the geographical limits of the division of the railway where the cause of action arose, or the headquarters of the concerned railway, or any other place with the written consent of both the parties. Now, my lords, there is no specific consent letter to that effect, firstly. And in 64.14, my lord.
You tell me why this matter should not be sent for arbitration.
Because, my lords, that is not provided for here, and we have already.
What do you mean it's not provided for?
My lords, we have already passed through those initial 60 days, my lords, where we.
Where does it say 60 days of the dispute? Where does it say that?
My lord, 64.14, page 34, my lords. Page 64, subclause 1, subclause 4. If the contractor does not prefer his specific and final claims in writing within a period of 90 days of receiving the intimation from the railways that a final bill is ready for payment, he or they will be deemed to have waived his or her claim. The railway shall be discharged and released of all liabilities under the contract in respect of these claims.
So how does this have any? This does not bar arbitration.
Then, my lord, 64, clause 3, A1.
Yes.
Where the total value of all claims in question added together does not exceed 10 lakh rupees, The arbitral tribunal shall consist of a sole arbitrator who shall be a gazetted officer of railway not below JA grade, nominated by the general manager. The sole arbitrator shall be appointed within 60 days from the date when a written and valid demand for arbitration is received by the GM.
So where is the demand for arbitration? You have to go for arbitration, Mr. Counsel. What is the claim? What is the value of the claim?
What is the value of the claim is 44,019. Well, 8,93,282. I apologize, my lords, that is not correct. I'll just calculate.
No, it doesn't matter. But why shouldn't this matter be sent for arbitration? That's all. This is a dispute between two parties. There is a arbitration clause. Supreme Court has said that when there is an alternative revenue available, you have to apply that.
My lords, if I may be granted one opportunity to satisfy
I'm waiting. We're waiting.
I will have to go through the tender notice once more, my lords.
The tender agreement is here. It's part of your readings.
Yes, my lords.
There's no question. When the arbitration clause there, you go for arbitration. That's all. Yes, you're for whom?
No, what is for our
Respondent number? Huh?
1.
Union of India.
Yes, Your Honor.
My lords, may I just pray, my lords? The performance report that they have spoken about in their affidavit in opposition, that may kindly be furnished, and on the next date, I will satisfy my lords that arbitration clause may not be in my case.
No.
Just one opportunity.
On the last date, you had asked for time.
Yes.
I'll reply.
Yes,
to the in opposition. So you have already been furnished affidavit or in opposition.
Of course, my lords, but that annexure is missing, my lords, which is very vital.
What does it matter, Mr. Counsel? When this matter cannot be decided here, let it be decided in arbitration. That's all. When there is a arbitration clause, you go for arbitration. Right. Heard, Mr. A. Barwa. Learned counsel for the petition. Also heard, Mr. Learned counsel appearing on behalf of Mr. Yangarwati. Learned CGC.
My lords, may I make one submission, my lords. Here in clause 64, it is provided that the arbitration clause may be invoked within 90 days of receiving of intimation from the railways that a final bill is ready for payment and delivery. In our case, our payment was never finalized. In fact, our earnest money was forfeited.
Let me see which page.
My lord, page 34.
Yes.
Page 64, 34.
Yes.
Clause 64(1) subclause 4, my lords.
Yes.
If the contractors do not prefer their specific and final claims in writing within a period of 90 days of receiving the intimation from the railways that a final bill is ready for payment, he or they will be deemed to have waived his or her claim, and the railway shall be discharged and released from all liabilities under the contract in respect of these claims. Here, my lords, it is not the case that they have settled the final bill and there is a dispute with regards to the bill amount. Here, our grievance is that they have terminated our agreement arbitrarily without giving us the required notice as per the agreement, the contract, and they have also forfeited our performance guarantee and the earnest money. Therefore, it is beyond the scope of the arbitration clause.
No. Where does it say beyond the scope?
Well, because it clearly says that the final bill is ready for payment. If we have a dispute regarding the final...
No. It's not with regard to that only.
Well, that is what the clause says, my lord, from my understanding. That is the only ground on which an arbitration can be invoked, my lords. That is the only limited ground in my humble submission, my lords.
8/10/24, 28/10/2014, as well as the letter dated 20/04/2015, issued by the Chief Medical Superintendent, Lumding, Northeast Frontier Railway, for forfeiture of earnest money and performance guarantee due to termination of the contract work pertaining to the tender notice dated 3/4/2014 for removal and disposal of garbage, inverted commas close, from Dimapur railway area for 2 years, from 1/7/2014 to 30/06/2016. The petitioner had been awarded the tender on 30/06/2014 at the tender value of 8,93,282 and has subsequently deposited a performance guarantee of rupees 44,664 and earnest money of rupees 19,330 in pursuance to the same. However, due to unsatisfactory performance of work, the contract was terminated on 28/10/2014 by the Chief Medical Superintendent with effect from 31/10/2014. Next paragraph. The petitioner has challenged the same and has prayed for a refund of the performance guarantee of 44,664 and earnest money of rupees 19,330. He has also prayed for payment of rupees 1,46,600 for works done by the petitioner. On perusing annexure, on perusing the terms and conditions of the agreement made between the parties, this court has noticed that there is an arbitration clause provided in the agreement wherein disputes between the parties are to be referred to arbitration. Interestingly, the full arbitration clause as provided in the arbitration agreement has not been annexed in the writ petition, in as much as page 34 of the writ petition, as much as page 33 of the writ petition relates to page 68 of the agreement, while page 34 of the writ petition relates to page 70 of the agreement. Page 69 of the agreement is not a part of the record. Next paragraph. In view of there being an alternative remedy available, which has been clearly set out in the arbitration, in the agreement executed between the parties, this court is not inclined to proceed further with the present case, and the petitioner would have to avail the arbitration clause provided in the agreement. In the case of so, I'll give you that. Next, in view of the reasons stated above, this writ petition is dismissed with liberty being given to the petitioner to approach to avail the arbitration clause for redressal of his grievance. Writ petition is dismissed.
One line may be added, my lord, that when the railways authorities are approached, they will duly consider my.
I don't know. No. We'll have to see. There might be delay also.
Obligement.
For admission, item number 4.
My lord, the State Respondents Council, she's appearing in court number 3.
You have not filed affidavit. You need to file affidavit.
She's here to receive.
Mr.
Miss Pichano.
Miss Pichano, learned government advocate, is granted a further 3 weeks' time to obtain instructions and file affidavit. In the matter of the 3 weeks.
For orders, item number 5 to 9.
Lordship, except for item number 8, in all the other matters, notice is completed upon the private respondent 3 to 9. However, as per the office note 11/3/2026, notice about respondent 9 has been returned unserved with the remark RTS.
What is RTS?
As per the book code, it says return to sender. So since in the other item notice is completed, in item number 8 also, service about respondent number 3 to 8 may be also deemed served.
Tell me one thing. What about the case? What is this case about?
Petitioners are challenging the Bune order dated 6/11/2025.
Page.
Passed by the Deputy Commissioner.
Page.
Page number 21, annexure 3. In which petition 43.
Yes, here for whom?
My lord, and for the state response. 1 and 2.
So what do we do, madam? So for this item, for items 5, we have to wait for the service report or what?
Lordship, we may be permitted to take fresh step upon respondent number 9 in the petition 43 for respondent number 9.
43. Just a minute. What about, we'll go one by one. What about 40 of 2025? What is to be done here?
Other, no, the remaining matters is already completed.
All complete?
Yeah.
No? What is not complete? In item 5 is not complete.
As per the office note 9/2025.
For which one? For which case?
For the read petition 40, 41 and 42.
40, it says there, 40, it says there, no one appears for respondents number 3 to 9. List this matters after 4 weeks.
Order dated, according to, as per the order dated 11/2025.
Give her the second copy of this page, of this item, of this the WPC 40. Second copy. Give it to her. You don't know how to look. Have you looked at the office note? Office note dated 24/2/26. Have you seen notice issued upon R number 9, 3 to 9? Just show me, I'll show you. You'll have got to learn how to look at this office note.
What should I take order dated 11/12/2025?
Of which case?
The common judgment. So I'm nervous.
In which case? Out 11/12/2025. 11/12/2025.
It's a common judgment.
11/12. 11/12. There is no 11/12 here. I've got the records. It is supposed to be in the records. If you have, it is supposed to be here.
It says, as proposed, now dated 9/12/2025, postal service report in respect of respondent number 3 to 9 in WPC 40, 41, and 42 have indicated that the items were delivered on 18/11/2025.
Why is it not here? It is not here. This order in 40. Interesting. Why is this order not here? Eleven chapter.
Not in the address.
Oh, it's not in the file. You see this order, come here. This order 11/12/2025. This it is not in the file. It should be in the file. It should be in. It has been made in 40 of 2025. Not only 40. It has been made in different writ petitions. There are 43 also. Common order. It is not here in the file. No, you tell them. Okay. It is 11/12/25. Yes, so madam, what?
Or we may be permitted to take precedent upon the respondent number 9 within 3 days.
In which case?
43, petition 43.
Why only 43? What about 40, 41, 42?
It's all completed.
Where does it say completed? I don't know this. From where do you get from? How do you say it's complete?
Since it's delivered, we assume that there is a.
No, court has not said that.
Yes, there's no says that. but
Deems it
said-
proper to wait for their appearance. Anyway, you make this, right. The order dated 11/12/2025 states as follows. Next paragraph. However, no one appears for the respondents number 3 to 9 in WPC 40, 41, and 42 of 2025. Mr.
LD Sankam.
LD Sankam appears for, additional AG appears for the states.
Respondent number 1.
Still respondent one. Miss
Hassan Jamil.
Hassan Jamir. Who's your parents? Any relationship with Banu and all? No.
No.
Mr. S.N. Jamir appears for
Petitioner. Petitioners.
petition. You have a color numbers here?
On behalf of my senior TP Chamber.
Appears on behalf of Mr. T.B. Jamir, the counsel for the petition.
TP Chamber.
TB, no? Maybe there's item 43. 43. Adjournment, no? You see, the problem is now the fresh steps. We do not know whether it will have any effect because it says return to sender, but it does not say why it has not been delivered, whether they have left the address, whether they are not accepting or what. So
the respondents are all same. Now, 3 to 7 are all same person, and respondent number 9 is a society. They are also respondent number 9 in the other cases as well. Press steps or maybe we can go with Dusty as well.
you try Dusty?
Upon only respondent number 9.
Why? Why 9 only?
Because only 9 is returned. It's after all.
But there are only 2 respondents.
No, we have.
In item 40, in WPC 43.
No, Doctor, we have we filed IA for implement that was allowed, and then
Then you have not.
I filed by amended process title as well.
It is not here amended cost title.
I filed on 20/01/2026.
Okay, right. Item 43, office note dated 11/3/26 states, notice issued upon the respondent number 9 has returned unserved with a remark on the envelope, bracket, not bracket, inverted commas, RTS. Full stop. In view of the above, the counsel for the petitioner prays that she may be allowed to serve notice upon the respondent number 3 to 9 by Dusty Service. Same address, no?
3 to 8 are same address, they are fact.
No.
And 9 is a society.
And they are all in Kohima, no, Dimapur. So you can serve upon them. No. Let me you see, the problem is that the post title is not here. So who is the head of the family?
Number 3.
3. Okay, 3 to 9 by Dusty Service. Dusty Service on 3 to 8, respondents 3 to 8 can be effected by serving notice upon respondent number 3. Who is the head of the family? Of respondents 3 to 8. Dusty Service?
3 is the grandmother, and 4 is daughter-in-law.
So who is the head?
The respondent number 3.
3. Then respondent, the petition shall also serve notice by way of Dusty mode upon the respondent number 9. They shall file affidavit of service within enough time, 2 weeks. Okay. 2 weeks. This is the matter after 2 weeks.
May it please, my lords.
My lords, may I just make a, I apologize, my lord, for this intervention. My lord, I just went through the soft copy of that agreement in item 3, my lords. The missing page is there, but inadvertently it was not printed in the records. My lords, in clause 24, I'll just read it, my lords. Clause 63, it states matters finally determined by the railway. All disputes and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to the GM, and the GM shall within 120 days after receipt of the contractor's representation make and notify decisions on all matters referred to by the contractor in writing, provided that matters for which, well, this is important, provision has been made in clauses 60 to 1 of the general conditions of contract or in any clause of the special conditions of the contract shall be deemed as accepted matters, matters not arbitrable, and decisions of the railway authority thereon shall be final and binding on the contractor, provided further that accepted matters shall stand specifically excluded from the purview of the arbitration clause. Now, my lords, they specifically refer to the general conditions of contract of 2010. I have the GCC of 2010, my lord, clause 62(1) specifically, which states the determination of the contract owing to the default of the contractor. Now it says if the contractor abandons the contract or persistently disregards the instructions of the engineer or contravene any provisions of the contract or fails to adhere to the agreed program of work by a margin of 10% of the stipulated period, in that case, the railway may terminate my contract. On the engineer on behalf of the railway may serve the contractor with a notice in writing to the effect that if the contractor does not within 7 days after the delivery of of such notice proceed to make good his default, insofar as the same is capable of being made good and carry on the work or comply with such directions as aforesaid to the entire satisfaction of the engineer, the railway shall be entitled, after giving 48 hours notice in writing under the hand of the engineer, to rescind the contract as a whole or in parts, and after expiry of 48 hours notice, a final termination notice should be issued and adopt the following courses. Now, my lords, my contention is that this 48 hours notice was not served to me and my contract was arbitrarily terminated. And this clause, my lords, is specifically exempted under clause 24 of the contract.
Did you write a letter to the railways with regard to this?
Yes, my lords. I have made a representation. In fact, I had sent a legal notice, my lords. The legal notice would be at page 47, my lords. Of course, I have not mentioned about the arbitration clause, my lord. I'll be fair on that because the client was not aware about this provision, my lords. Only later on during the filing of this case, I had come across this, that this is not an arbitration.
This matter pertains to termination in 2014.
My lords, yes.
And now you have filed this case in 2025.
My lords, yes.
7 years delay.
That I accept, my lord. That I have no defense on that, my lords. But the only thing is that I had been following up, my lords, through legal notices and also orally physically visiting the offices, my lords, to consider my case, but no favorable responses had been received, because of which even belatedly I have approached this honorable court, my lord, as a last instance. Because this is also not subject to arbitration, I'll be left remediless, my lords.
No, but then that's when you sleep over your rights, you lose your right.
Yes, my lords.
11 years is too late in the day.
I humbly bow down, my lords. To that I cannot raise an objection.
Then you go in arbitration.
My lords, but I have just pointed out, my lords, it's not an arbitrable dispute. That is my only difficulty, my lords.
How is it not arbitrable? I don't understand. You are not even availed of the provision therein by writing a representation to the authorities.
Because, my lord, the arbitration clause clearly states that if my dispute falls under clause 62 of the general conditions of contract, it will not be an arbitrable dispute. And that clause,
what does clause 62 say?
Clause 62, my lords, I'll read it once. Clause 62 says determination of contract owing to default of the contractor. And one of the grounds is that if I have persistently disregarded the instruction of the engineers or contravened any provisions of the contract. Now, the ground on which my contract was terminated was because they are saying that I have refused to remedy the defects pointed out by them, and
you were persistently not doing the contract work in time.
My lord, that is not the case, my lords, because they had issued.
That is the stand that they have taken.
My lords, my submission is that the very first notice of warning that was given to me was even prior to me entering into the agreement with the railways, my lords. Therefore, if they start giving me penalty notices without giving me an opportunity to improve myself, my lords, that will be an unfair deal on my part, my lords.
When was the contract given to you?
My lords, the contract was awarded to me on 25/7/2014.
And within a month?
Yes, my lords. My first notice was given on 9/7/2014, which is prior to the date of my agreement, my lord. Even before I have come to know about my terms and obligations under the contract, I have been served with the first termination notice.
That lawyer has gone.
Well, he came to seek time, so he would not have any instructions. Therefore, my lords, only to that.
We have passed an order in court.
My lords, may I kindly pray to reconsider, because if it is dismissed, my lords, I will have no remedy, my lords.
You have not given a copy of the thing to me.
My lords, I will serve it positively on the next date, my lords.
No, you serve it today. You bring it, you send it somehow today.
Very well, my lords.
I'll do this matter tomorrow and tell the commander to come. His name is there, I think. No? Just call him up and come. Tomorrow at 10:30. No.
Very well, my lords. Very well, my lords. I'm so obliged for the patient hearing, my lords. I'm so obliged.
You send it by today. And
Yes, my lords. I'll arrange for it. I'll arrange for it, my lords. So obliged.
Tell the matter.
Untuk